So in a frustrating decision, the Supreme Court just denied emergency review in the case challenging the state of New York's new concealed carry laws, which it passed in direct defiance to the Supreme Court's New York State Rifle and Pistol Association v. Bruen ruling. So let's talk about this. But real quick before we jump into this video, I just want to mention that the Gundy's voting is currently open. I'm nominated once again for Top 2A Voices. Last year, I won the award for Top 2A Voices, so I would love to win 2 years in a row. If you think I deserve that vote, you can vote down below using one of the links. It'll be in the detail section and also in the comment section. And if you vote every single day, the Gundy's Award is giving away a ton of prizes, including a grand prize of you winning a trip out to the event to attend with everybody that's going. As I mentioned in the intro, this morning we received an order from the Supreme Court in the Antioch v. Negrelli case. In the decision, the Supreme Court denied the emergency application to vacate the stay of the Second Circuit. However, in the order, the Supreme Court issued a warning down to the Second Circuit. Now, if you're not familiar with what's going on in this case arises out of a lawsuit filed by GOA against the state of New York because of the new concealed carry law, which they passed in direct defiance to the recent Supreme Court ruling in Bruen. Because of how this law directly violated the Second Amendment and that decision, GOA filed a lawsuit against the state of New York. In the case, Judge Sotheby, the district court judge there, heard the GOA request for a preliminary injunction and ultimately granted the request for a preliminary injunction against various aspects of the CCIA. In that decision, he struck down portions of the law, including the good moral character standard and also the catch-all sensitive location restrictions. After that, New York, of course, was not going to live with that, so they appealed the granting of the preliminary injunction up to the Second Circuit and requested that the Second Circuit place a stay on that judgment. The Second Circuit ultimately did grant that stay, which prevents the Judge Sotheby preliminary injunction ruling from having any current impact. Now, instead of waiting around for the Second Circuit to finally decide that this topic is important and get around to actually hearing this case, GOA has filed an emergency application up to the Supreme Court. The emergency application asked the Supreme Court to vacate the Second Circuit's grant of that stay. Now, this application was originally filed to Justice Sonia Sotomayor, who is the justice responsible for reviewing emergency filings which come out of the Second Circuit. And after that happened, the question was, what would she ultimately decide to do? Well, today we received the decision of the court. It states, the application to vacate stay presented to Justice Sonia Sotomayor and by her referred to the court is denied. So there's something important. Justice Sonia Sotomayor did in fact refer it to the full court for consideration. However, along with that denial, there was a statement which was issued by Justice Alito and was also joined in by Justice Thomas. And it is in regards to the denial of the application and has some clarification language on, I guess, why they decided to do this. It states, statement of Justice Alito with whom Justice Thomas joins respecting the denial of the application to vacate stay. The New York law at issue in this application presents novel and serious questions under both the First and Second Amendments. The district court found in a thorough opinion that the applicants were likely to succeed on a number of their claims, and it issued a preliminary injunction as to 12 provisions of the challenged law. With one exception, the Second Circuit issued a stay of the injunction in full, and in doing so, did not provide any explanation for its ruling. In parallel cases presenting related issues, the Second Circuit has likewise issued unreasoned summary stay orders, but in those cases, it has ordered expedited briefing. I understand the court's denial today to reflect respect for the Second Circuit's procedures in managing its own docket, rather than expressing any view on the merits of this case. Applicants should not be deterred by today's order from again seeking relief if the Second Circuit does not, within a reasonable time, provide an explanation for its stay order or expedite consideration of the appeal. So that is the order that we got from the Supreme Court on the Antioch case. Again, that is the challenge to the New York Concealed Carry Improvement Act. So this is actually a frustrating decision to me. I know a lot of people are likely going to be frustrated by this because, again, it is the Supreme Court giving the Second Circuit, the lower courts, and the state of New York another chance to essentially do the right thing. Again, one of the first major things you should take away from this is that Justice Sonia Sotomayor did in fact refer this to the full court for a vote. So it's not like she did this on her own. And we had talked about in the past that If she had kind of ruled on this on her own, if she denied the application on her own, then you could kind of shop around and seek a review from one of the other justices. But instead, this was referred to a full court vote. So this was a decision by the full Supreme Court. And that also means that since this was referred to the full court, there wasn't enough support to actually grant the relief which was requested in the emergency application. Essentially, the order states that the Supreme Court, for some reason, is going to give the Second Circuit another opportunity to essentially do the right thing. The Supreme Court, for some reason, acts as if they don't want to step on the toes of the Second Circuit. They want to respect their control of their own docket, of their own procedures, but did issue a warning, which you heard in that order. I guess if you want to pull some silver linings out of this decision, there really are two things that you can pull out of this and that are kind of important. First, they warned the Second Circuit that since they granted the stay, they must either issue an explanation for its granting of that stay, or they need to expedite the appeal process in the briefing on the appeal. In fact, in that language, you saw that Justice Alito said that he is not going to deter, or he's not trying to deter the plaintiffs here from seeking the same type of emergency relief from the Supreme Court if the Second Circuit decides that they want to continue to drag their feet. And the second really important thing that needs to be pointed out with this order is that the Supreme Court's denial here is not upholding or agreeing with the constitutionality of the CCIA. Just an hour after the order came out, New York's Attorney General Letitia James issued a press release claiming that the Supreme Court ruled in the state's favor and how this was such a significant win for them and all that stuff, those typical talking points, which just wasn't true at all. In fact, if you read the order, which I read to you, the order expressly states that the decision was made not based on the merits of the case. It was simply made kind of on a procedural aspect. This means that they aren't issuing a judgment on whether the CCIA is constitutional or not. Instead, their decision was focused more on giving the Second Circuit a procedural chance to correct their errors. Now, you may be asking yourself whether this means other emergency applications, like in the Gazzola case, that case is now doomed. And the odds are that it's probably not in that case's favor, but you have to remember that the Gazzola case is in a different position. In the Gazzola case, the district court upheld the CCIA, and then the Third Circuit panel there denied the appeal. That means that the Gazzola case is in a much different procedural posture and a different position than the Antioch case. So maybe it is that the Supreme Court maybe would like that one more because it's in a different procedural position than the Antioch case, but I don't have a whole lot of faith in that. Also, keep in mind, I'm just going to mention this in passing, and maybe I'll do a more comprehensive breakdown on this, but the Gazzola case is also seeking a different mechanism right now, which is a writ of cert before judgment, which is something completely different. They are also seeking an emergency application, similar to the Antioch case, but then they are also filing a different petition, which is for a writ of cert before judgment. And again, I might go into that in a later video. So definitely not the result we wanted, but I needed to let everybody know and kind of update you on what's currently going on. Now we will be keeping our eyes on what the Second Circuit ultimately decides to do and if they will respond fast like the Supreme Court requests. But for now, that's where the challenge to the New York CCIA law currently stands. If you have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.